their career trajectory, what they do now, maybe a little bit of a day in the life of. So I just to mention, this is being recorded, just so you're all aware. I think you should see a little pop up there for that. And obviously we welcome questions. Please put on your camera and your microphone to ask questions, and of course you can ask questions in the chat as well. Whatever you want, we're very happy to try and answer questions as best we can. So yeah, so welcome to everybody. Thanks very much. I'm going to hand over to Fionn from City Law School just to say a few words, and then we'll hear from Catherine briefly, our sponsor from Thomson Reuters today. So thank you very much for that. And then we'll start working through the panel, starting I think with Ian, because he has to leave at 6:30. So that's just to make you all aware, if he disappears, not to panic. So thank you, and over to Fionn.
Thank you very much, Dan. It's good to see everyone this evening, and thank you, Catherine, for being here and supporting the event. It's lovely that you're here. I'll try and talk until 6:05 because quite often the city students are coming out at 6, so it gives them a couple of minutes to log on, and I can see a number of them are logging on as we speak. So City University is very pleased to continue collaborating with BACFI, and we're very grateful for this event being held for our students at the beginning of the academic year. Students always, here's Gaynor. Students enjoy this event very much, and I think what they are and enjoy hearing about is the varied and exciting different opportunities there are at the employed bar, and also hearing about how to undertake a pupillage at the employed bar, because many of our students would like to start straight away effectively, and we know that there are many different routes to do that, so we're interested and excited to hear about that. Students that are listening, BACFI do share all their events over the year with us, and we will be sending those out to you over the year, so do keep an eye out for the events, and they will all be advertised on Lawbor for you, and you may also join if you wish as a student. That is available for you already. So Dan, thanks very much. I can answer any student questions that come in the chat, and over to you. Thank you.
Thank you very much. Yeah, I'm just going to pass over to Catherine briefly, but just to mention on events, I think there is one that's coming up that I should mention, which is the Denning lecture. It's out the 3rd of December. Sandra, please, just to confirm that, if that's possible. That's right. Oh, no. Are you going to share the flyer? Is that exciting? I'm hoping. My screen's gone a bit strange. I'm not sure how it is for everyone else, but I'm hoping Sandra is sharing the flyer. But yes, the Denning lecture is either the 3rd or the 4th of December. So that's an event which is well worth coming along to. Yeah, sorry, Sandra, I can't see anything if you were sharing your screen, but I've got a white screen. So passing over to Catherine Brewer now. Thank you very much. If you'd like to say a few words, we'd be very interested in hearing.
Sure.
Thank you.
That would be great. Thank you. So good evening, everyone. My name is Catherine Brewer, and I'm Publishing Director at Thomson Reuters for the UK and Ireland. Thomson Reuters is delighted to be sponsoring BACFI's student event this evening. Thank you, BACFI, for allowing me a couple of minutes before the main event to introduce myself. 2024 marks a significant anniversary for Sweet and Maxwell. It's 225 years since Stephen Sweet and Alexander Maxwell set up shop in Bell Yard off Fleet Street, next to where the RCJ is now. Since 1799, there have been many important changes in the history of our business, many important chapters, one might say. Our company expanded with the addition of a Scottish arm, W. Green, in 1956, and then moved into the Irish market in 1994 with Roundhill. Technology and digitisation have, of course, changed all aspects of our business, the law, and the way in which you all consume legal information. As publishers, we no longer have to deal with handwritten manuscripts, nor is typesetting done laboriously, letter by letter. Although we still produce our publications in print, very much so, they are also now available as ebooks and online. Thomson Reuters has developed a proprietary ebook platform, ProView, specifically for legal professionals, which delivers market-leading publications digitally, but in the same familiar format as the print. Furthermore, Thomson Reuters is now recognised as one of the leading AI and technology companies for professionals, adding generative AI to the strong foundations and trusted content of Westlaw and Practical Law. However, what continues to surprise and inspire me, along with all the technological developments and change, is how much has stayed the same. Many of the publications established in the early years of Sweet and Maxwell still continue to this day, even if in their current format they wouldn't be recognisable to Sweet and Maxwell's earliest customers. For example, the first edition of Chitty, published in 1826, whereas the annual practice, now better known as the White Book, was first published in 1883. We're proud of the part our publications play in the legal community at Thomson Reuters. We know that our key texts are fundamental tools of the trade. We also recognise that for those starting out in their career, publications are quite an investment. Therefore, I wanted to use this opportunity to let you know that we offer a significant discount on White Book subscriptions to barristers within 3 years of call. The details of the offer are on the screen, and BACFI have kindly agreed to send out the same information after today's event. But I won't keep you from the main event any longer. Thank you for your attention, and I hope you all enjoy this evening.
Brilliant. Thank you very much. Just yeah, that's a great discount as well, actually. I mean, they can be quite pricey, so if you can take advantage of that, and if it's of use, I would urge you to do so. Having checked the Denning lecture, it is the 3rd of December, so just put that in your diaries and be in touch with Sandra if you want to come. So this is talk about employed barristers, and I thought it was just worth kicking off to explain a little bit. Obviously, most of you probably know about the distinction between solicitors and barristers. That is to say that there's sort of different routes of qualification, and the fact that barristers do pupillage and are ultimately qualified to appear in court and do a lot of advocacy traditionally in court. Whereas those barristers tend to be self-employed and grouped together in what are called chambers. There's also the option for barristers to be employed by a variety of organisations, which then obviously has certain benefits and potentially disadvantages depending on your priorities. But that is sort of what we're going to explore with you this evening, just to explain how those variety of organisations can accommodate you as an employed barrister and use the skills that you have developed as a barrister if that's the route you go down. So just to introduce Ian, thank you for dressing up so smartly, Ian. You put me to shame, but at least someone has, so thank you for that. So Ian, would you like to explain a little bit about perhaps how you qualified and why you became a barrister and how you ended up in the employed bar, and a little bit about your day-to-day life? I might ask some more questions, but that should be enough to start you off.
Yeah, well, my current role is I'm an in-house lawyer for Lloyds Banking Group, and I work in the insurance division as a commercial lawyer. Employed barristers, many of us are employed as in-house barristers, working for a whole range of different types of organisations, from charities to companies to the government, etc. My route to the employed bar was that I did the bar finals course, as it was called then, and when I was looking for pupillage, I got a first 6 months in a barrister's chambers, which was your traditional way of doing pupillage. But in my second 6 months, I was lucky to get one of the few pupillages with an employed barrister who was a legal advisor to a telecoms manufacturer, a technology company. So I went there from the traditional bar to work for this company, and I must say that the second 6 months in industry was really fantastic. I think I learned more skills and knowledge in those second 6 months than I did with my traditional pupillage. And with my training there, I did a range of work such as managing litigation, right through to doing commercial contracts. And then when I completed my second 6 months, I was offered a job as a commercial lawyer for that company. And then from then on, I moved on to work for an IT outsourcing company as in-house counsel, and then worked for a very large telecoms company for many years, where I did a variety of legal roles, including heading a legal team and also being a major deals lawyer on large transactions where companies were outsourcing their IT and telecoms to the company that I work for. After about 16 years, I decided for a change, and for about 10 years, I became freelance, doing various short-term interim legal roles, but all in-house. And I worked for an energy company, I worked for a pensions provider, and a fintech before I joined Lloyds Banking Group. And in Lloyds, I've done a variety of roles. I started off working in the team that supported major technology procurement, but then moved across to insurance, where I deal with contracts with distributors, suppliers, etc. And one of the benefits of working for a large organization is that I was also able to do a secondment for nearly 12 months as an inclusion and diversity manager for the legal team. I mean, companies like Lloyds Banking Group, they employ about 350 people in the legal and secretariat department. So quite a large department, and that gives you a whole range of different career choices. So hopefully that gives a taste of some of the things that I've done. Dan, do you have any more questions?
Yeah, I was sort of interested. Were you just seduced after your first taste of the things that employed people get up to in law that you'd never looked back, or was there anything more sort of thought out, or as time went on, you just appreciated it? You sort of how did you end up staying on that trajectory, I suppose?
I was very fortunate that my father was a buyer, a procurement manager for various large companies, and he made me aware of in-house legal teams. So I was aware that that was a career option. It took me about a year or so to get a pupillage after I'd been called to the bar. So during that time, I worked in the legal department of a health authority. So I had some insight into the work of an in-house lawyer. So when I saw the opportunity of doing pupillage in-house, then I kind of jumped at the chance. And because I like being involved in an organisation whose purpose is not necessarily to deliver legal services, but actually to provide goods and services to customers,
So
and to be part of
looked
that
back.
team.
It sounds like you never looked back. You found
No,
your place and never looked back.
no.
There's a question from Michael just in the chat, which I think we can deal with now because obviously you've got to go shortly. So maybe it's a useful thing. He's asking, how often do you put your oral advocacy to use? Which is obviously interesting because I think probably as a rule, most employed barristers are not really in court that much, but of course oral advocacy can mean a lot of different things. So how would you answer that question?
First of all, particularly if you work in the in-house litigation teams, then you will have chance to do traditional advocacy. And in my early days as an in-house lawyer, I did some employment tribunals to represent the company as the employer. So that and I when I worked at the telecoms company, their employment team encouraged people to get higher rights of audience to appear in the superior court. So there are chances to do traditional advocacy, and many of our members are members of regulatory bodies in the professions, and they represent people in the tribunals that those professional bodies do. As a commercial lawyer, I would say that my advocacy is used because I'm involved in commercial negotiations with suppliers and with other third parties. I have to present things to various management teams and board meetings. So all of that is using your advocacy skills. When I worked for a pension company, I had to stand before the board of trustees to present recommendations for them to make an informed decision. So, and in all those forums, you are challenged, people ask questions, and you're using your skills as an advocate to answer those questions. So I think advocacy skills are used all the time in-house.
Brilliant. No, thank you very much. That's great. I don't have any other questions at the moment. Obviously, if anyone else has any questions for Ian, you've got a sort of 13-minute window. So feel free to put it in the chat and we'll try and circle back to him if anyone does have any Ian specific questions. Otherwise, I propose to introduce Gaynor, and I believe she's on the call. Gaynor, are you there?
I am here, yes.
Hello. This is
hello.
Gaynor, everyone. She's chair of BACFI, so a very important person, and she's going to explain a little bit about her own journey and perhaps answer that same question about oral advocacy on the way as well, please.
Sure, yeah, I'll try and cover it off, Dan, as we go. So thank you. And I apologise, I've had a chest infection, so my throat is kind of on and off. So bear with me if it just disappears. So yeah, as Dan said, I'm General Counsel at CLS. So CLS, you won't have heard of it, I'm sure, is a financial market infrastructure, often referred to as an FMI. So we are unique. So we are one of the leading, well, the actual leading provider of FX settlement services. We launched in 2002, and we do kind of multilateral netting and settlement. So we have over 70 members, and they tend to be the biggest financial institutions. So, you know, the Goldman Sachs, the Morgan Stanleys, the JP Morgans, etc. And we settle many trillions of US dollars every day. So it's kind of up to me to look after the legal framework that underpins all of that, and to make sure that in every jurisdiction that we're in, for every currency and for everywhere that we've got a participant and a member, that it works. And to make sure that insolvency doesn't impact anything that we've done from a settlement perspective. So it's quite a responsible position. And I hold my breath every morning until settlement's been done, just to make sure that there's no issues. But I do love my job. I mean, I literally do anything that has a legal touch point, which makes it sometimes quite complex and challenging and definitely stressful, but it is actually fascinating. I spend a lot of time analysing legislation and interpreting legislation and then applying it on a practical level. So kind of, what does this really mean to us? I've got about 30 lawyers, actually not all lawyers. So I cover legal, regulatory relations, records management and data protection. So 30 or so is not massive for a financial institution, but it's big enough for what we do. I have one other barrister in my team in London, and the rest are solicitors. And we're kind of split across London and New York. So I spend a lot of time in New York dealing with, obviously, the team that I've got over there. Obviously, I have a lot of external counsel arrangements as well and relationships, so I look after all of those. And the way we organise ourselves internally is that we'll kind of all specialise in something. We'll take ownership of a certain area or a certain jurisdiction, and everyone has that kind of specialism and interest. But ultimately, we all do a little bit of everything, and I think that's the way lawyers grow best. They all want to do more, they want to learn more, and they want to see lots of different things. But obviously, we're quite niche in terms of what we do. So you have to develop that specialism as well. So I report directly to the CEO and directly to the board. So I attend all board meetings that we have, and we have quite a lot over the course of the year. And I also attend all regulatory meetings. I regularly advocate in different jurisdictions for changes to legislation. So in terms of that legal framework that I talked about, that's underpinned by law in most of the jurisdictions that we operate. So occasionally there'll be a change in legislation. I don't know, for example, Israel might change their legislation. It might seem like there's no impact, but actually what we find is often there's an unintended impact, and it can be a kind of oblique impact. So we have to really understand the legal kind of framework in those jurisdictions. So it's quite interesting. I'm also on the executive management committee. So as well as being a lawyer, I kind of have that other hat where I've got to think about what's best for the group of companies as well. And I'm making decisions all the time that are not legal. And I also lead the DE&I Council and the Women's Forum. I'm a bencher at Gray's Inn, qualified in '94. So I've been kind of doing this for quite a long time. So I think, Dan, to your point about advocacy, I do a lot of advocacy. So I'm regularly talking to the Executive Management Committee about presentations on legal matters, advising on various things, talking to the board about various things. Like I said, you know, going into different jurisdictions and advocating. Sometimes that's on paper. So we've not got to lose sight of the fact that there's not always about oral advocacy. It can be about written advocacy as well. So there's quite a broad range. And I think, you know, what I find and what frustrates me is that when I see my kids kind of coming up through university and looking at the way the profession has been kind of shown to them and to their cohort, it's all about going to court. It's all about the wig and the gown. It's all about being in chambers. And there's very little kind of said out there about the employed bar and about the kind of richness that can bring to you, and all the different things that you can be doing on a day-to-day basis. But not only that, there's also the security piece of it as well, you know. So I went on maternity leave twice, you know, I was paid for all of that. I get really good holiday, I get benefits, you know, I get bonus payments, you know, so it all kind of is very secure from that point of view, or as secure as any job can be. So it does have its advantages as well. So I think that, you know, there's a lot to be said for the employed bar, I think, and people, unless you're in it, you just don't realise what's out there. And I think the more you can build your kind of experience base as you move towards pupillage and really get a sense, you know, go into some of these organisations and look at exactly what people are doing day to day, I think you'd find that you'd be surprised how exciting and fast-paced and rich that environment can be. And obviously I'm just speaking from the commercial perspective, from a financial commercial perspective, but you know, I do tons of things. I do, you know, tax law, employment law, you know, as Ian alluded to. You know, there's so much out there. It's not just about your kind of niche area and your legal framework piece. It's much broader than that, and people come to you with anything. You know, if it's, you know, the toilets aren't working, go and talk to Gaynor because there might be a contract point, you know. So it's just there's so much that you can get involved in, and you have a little bit of an ownership for what you want to do as well. You know, you can grow to be the point person for certain things, and you can kind of develop your own practice accordingly. So yeah, I think it's a really rich place to be if that's where you want to go. Brilliant,
thank you. And can you just perhaps tell us how you qualified, that sort of those early stages? I think that might be of interest to people. Yeah, so I was from Manchester originally, and when I was kind of qualifying, no one ever talked to me about employed barristers at all. So as far as I was concerned, I wanted to go to London and I wanted to go into chambers, and that was the pathway. But actually, and I did do that. So I didn't take pupillage in Manchester. I went to London instead. And I did kind of enjoy it, but I wasn't loving it, I have to say, in pupillage. And that's when I kind of started to think about what else might be out there. I just couldn't see myself enjoying that life going forward. You know, really the kind of things that were happening to me was I was getting put on a train to go to Birmingham for a plea and directions hearing. I was on a train at like 6 a.m. and then I'd sit in the court all day for a 10-minute hearing, and then I'd get paid just really to cover
not much, just cover my train ticket and a little bit more. And I know that's not the experience of everyone, but that is the experience of some junior barristers. So there has to be a realism there. And I just wasn't enjoying it, was the main thing. And I wasn't enjoying the fact that I was getting return briefs quite a lot. So I would get a brief, you know, the night before and have to go to court the next morning with just very little paperwork and not really knowing what I was getting into, and having to mitigate for people that I felt they deserved more, you know, deserved more focus from me. And that I just wasn't happy with the way the system was working. So that was my reason really for getting out. And I didn't know where I was going to go, in all honesty. I just looked around. I went to some recruitment agencies, and then someone came up with, hey, you know, JP Morgan have got a consultancy role. Do you want to take that? And I was like, who are JP Morgan? I've never heard of them. So kind of dived into that. And I think that's kind of what I've done all the way along my career, is just kind of, okay, I'll give it a try, see what comes. And, you know, if it doesn't work out, it doesn't work out, and just try it really. So that was kind of how I ended up where I am.
Brilliant. No, thank you. I think what's really interesting is that obviously there's some words you've used in your presentation which people might not be familiar with at their stage, or their sort of general knowledge. You've mentioned FX, you mentioned mitigation, lots of sort of terms there, but it just sort of shows the breadth of the experience that you have. And I think the real lesson, I think what I'm getting, is this idea that it might not suit everybody, but it might suit a lot of people. And therefore, what everybody needs to be doing is figuring out what they like doing, where they like doing it, and who they like doing it with. Because, you know, if they like, as you say, arguing difficult points with little paperwork and not much time to think about it, but on their own, then maybe the employed bar is not necessarily for them. But if, on the other hand, you like working with a team and having time to prepare and some kind of security of an organization, then maybe it is. So I think everybody's on their own journey to discover what they like, and it takes time. And sometimes I've known people who just didn't like the particular area of law that they were working in, or the particular way it was practiced, and have dropped out of pupilages and things like that. It's just, you have to find out what suits you. So I think what we're trying to do here is trying to share information so that you are a better informed group of people to be able to do that. So thank you very much for that, Gaynor. Now I can see there's a lot of chat about pupillage opportunities, and obviously that's something we get every year, and people are obviously very keen to talk about it. I suggest that we perhaps leave that discussion until the end to talk about where you might find pupilages and what might be necessary to get one and all that sort of thing. I believe there might be a list somewhere of employed bar pupilages which can potentially be circulated, but Sandra will correct me if I'm wrong. But if we can leave that to the end, that might just be helpful, and we can perhaps have a more dynamic conversation at the end about that as well. So unless anyone's got any specific questions for Gaynor, I'm going to move on. The running order, most recent running order suggests I should go to Alex next, but the running order before that I had said Charlotte. So I'm going to go Charlotte because I want to mix it up a little bit. Sorry about that, Charlotte. And I say that because Charlotte has been both employed and is now self-employed. So she's evidence of the flexibility of being able to move between those two states. And I think we'll have a lot of interesting things to say. So if you could introduce yourself, Charlotte, explain your journey and what life is like to you on a day-to-day basis, that would be great.
Absolutely. Thank you all for attending in the first instance. So I tried to be really straightforward about my journey to the Bar of England and Wales, self-employed or employed. So in terms of my origin story, if you like superhero stories, I'm not a superhero, just a barrister. I grew up in the home counties. I went to a prep school, so an independent, a private school. I then went to a grammar school where it was quite academic. And then I read law and French law at University College London. I didn't do any postgraduate qualifications because I couldn't afford it. So even though I wanted to, it just wasn't viable. So I did various bits of work experience. I went to the European Commission, I worked for the Ministry of Justice, I did mooting, I did all of this stuff. And then I did a self-employed pupillage because as Alex said in the chat, at that time, no one really spoke to me about the employed bar. The employed bar wasn't a thing. that was in my purview at all. Hadn't heard of it, not a clue, a complete anathema, to be honest with you, until later on in my career. So I was in a set of chambers doing all kinds of civil law, no crime, no family, but anything civil. So I do personal injury, clinical negligence, professional negligence, breach of contract, all of that good stuff. For various reasons, it didn't work out in a set of chambers where I'd done my pupillage. So I took an opportunity to go to the employed bar. And I went to work at the Bank of England. So that's a United Kingdom central bank. And I was there for half a decade. And then subsequent to that, I went into a multinational law firm called Pinsent Masons, where I was there again just for half a decade. So the majority of my career has actually been as an employed barrister. And then I decided that I wanted to be self-employed again. So I've gone into chambers at Three Hare Court. I've been there for just back at self-employed practice for a year and a half now, just over that. And I do commercial chancery work. And probably go to court maybe once every sort of 2 weeks or so, unless there's a trial or something chunkier. But to go back to Dan's original questions about what my day-to-day life was like in a bank, I would echo everything that Gaynor has said, in that I can already see the question I expected. Why did you go back to become self-employed? We'll come to that. But just in terms of day-to-day life at the bank, when I joined the bank, there were only 40 lawyers who served over 4,500 people. So that meant that you had a really broad range of issues that you would cover as a junior practitioner. So that might be, for example, in a current climate with the crisis in the Middle East, various governments that bank in the bank would need money, foreign exchange, and would be doing foreign exchange transactions. So you might be advising on how to conclude those contracts, but you might also be advising about modern slavery in the pipeline of transactions that are happening, and you might be advising about public international law and the responsibilities that the bank had, that the contracting government had. So the bank has bank accounts for all the major governments and supranationals in the world. I might have to advise the then governor, Mark Carney, about something. I might have to use my advocacy skills before the court of the bank, which is actually just a board of directors. But it's like having sort of 8 or 9 eyes of Sauron upon you. So you'll have the governor, deputy governor, executive directors, and you will have to present a proposition, and they will ask different questions of you, almost like a Supreme Court. And there are also other decision makers within the bank that you will have to present to, which is kind of similar to a tribunal, about different issues, particularly if the part of the bank that does what's called enforcement, so that tells banks and insurers that they have done bad things, which hardly ever happens, then you would have to go before a decision maker and help your internal clients who wanted to punish the bad bank persuade the what was called the Prudential Regulation Authority about why it should take a certain decision. So perhaps fine a bank, or fine an insurer, or stop someone from being a director of a bank. So and sometimes advise on sort of quite quasi policy things. So G8, G7, the UK's role in the global economy and the legal ramifications of that. So it's kind of like a hybrid solicitor, barrister, policymaker, so varied, so intellectually stimulating, and such a privilege to work in that environment. And I gained knowledge that I could not have obtained anywhere else, and that I could not have obtained as part of a standard pupillage process. So I'm a very, very, very strong advocate of people spending time in an employed environment, because there are skills that I could not have obtained during my sort of traditional self-employed life. The answer to the question because I'm conscious of time and I don't want to eat into Alex's time as well, but there might be time for questions at the end. Why did I go back to self-employed practice? I had been at a law firm just before I went back into self-employed practice, and a law firm is quite a controlled environment. So I did actually do advocacy. I did go to court, but I also conducted litigation. So that means signing the sort of claim form, filling out application notices for clients, helping clients all the way through the litigation journey. But that's quite hard, basically doing a solicitor's job and a barrister's job. And in a law firm, as you're more senior, you'll have management responsibilities as well. And I didn't want to do the solicitor's job element anymore. And I also didn't want the management responsibilities. And I also wanted greater control over my practice. And I also didn't want a limit on my earnings. So as a self-employed person, yes, there can be difficulties in terms of stability. I've never had any. To be candid, in my career ever, certainly not the civil bar, and certainly not at the commercial bar do I know many people or any people that have those difficulties in terms of stability. And I think that's important to say, particularly coming from my background. I didn't come from money. I don't have a trust fund. I don't have anything to fall back on. So knowing that you can work in a profession and have financial stability, whichever way you choose to work, is important as well. But yes, I wanted to go to court much more regularly than I had, and just direct my practice more and do more international work as well. So that was one of the drivers for me. But that said, everything that I have employed, fundamental and necessary foundation for my success as a self-employed practitioner. Like I wouldn't have been able to join my chambers. I wouldn't be as successful as I have been in a past year and a half without the employed bar and the support of employed colleagues. So I am extremely enthusiastic about it and remain enthusiastic about it.
Amazing, thank you. And I should just say that you're also a committee member of BACFI as well, so that's evidence of your enthusiasm. Do you see yourself potentially going back into employment at some point? Is that something that's on the cards at the moment, or you're just trying to avoid management so much that it's not going to happen?
No, I think just because of the nature of my practice, I won't go back to employment. I have a Caribbean practice, which is something actually that I did before I went to my set of chambers. And that's not really something that I can do very well in an employed environment. Also, now I have a sort of portfolio career, which again is a little bit more difficult to do in an employed environment. So I'm a legal advisor to the ACCA now. I do little bits of teaching. And also I like having unlimited annual leave. So for example, I'll be off for a month.
That's very self-employed barrister. Yeah.
I'll be off for a month in December to spend time with my family in the Caribbean. And it's quite difficult to, say to your manager, I'll see you when I see you, not coming back for a month, but I can do that at the moment. Yeah.
Amazing. So, I mean, it's a good advert, obviously, for the bar as a whole, I would say, the things that you've been explaining, because again, just to reiterate, it's really a question of what you want at what particular stage of your life, and it's all there for the taking. It's just a question of making sure you're aware of it and potentially arrange yourself to make the most of it. So again, that's what partly this talk is about. So thank you very much. Do we have any specific questions for Charlotte before we move on? I can't see any in the chat. One person did ask about financial services. Yeah, I think Alex has just answered that one, actually. I was going to say, so we're coming on to Alex, and she is also in financial services. And I think it's partly because of the size of the institutions. I mean, Alex can expand on this in a second, but I think that's certainly a large part of the BACFI committee, I think, have a link to financial institutions. It's not the only thing by any means. It just seems to be well represented there. So I think we obviously will try and explain that there are other employed bar providers like the CPS or General Nursing Midwifery Council or whatever it's called, various regulators like that. Do you know anything about any of those, Charlotte, just before we move on?
Oh, sorry, I just put myself on mute. Yeah, absolutely. So as distinct from regulators, there are also law firms such as DWF or DAC that have their own sort of basically barrister arms, and they do a really wide range of work. DAC is very well known for public law. You have charitable third sector organisations like the Public Law Project. So that's more of those human rights type issues that people tend to think are much cooler than the work that I do, although my work does involve human rights as well. Article 1, Protocol 1, rights property is important, money is property. And that comes up a lot in my practice, oddly enough. So yeah, a really broad range of work, including sort of Christian charities as well, faith charities who employ barristers to solely do advocacy based on faith relevant issues, so right to life and alike. So really, really broad.
Amazing. Thank you. Thank you so much. So now introducing Alex. Well, Alex can introduce herself really, but Alex is also a committee member at BACFI. And as I said, in the financial sector. And so please feel free to explain a bit more about that and give a day in the life as well as how you got into this business, please.
Thanks, Dan. Very happy to do so. And yes, I am currently in the financial services sector. I'm head of financial services regulation at a French bank called Société Générale, which has a UK presence, and I'm in the UK. But I wasn't always in financial services. And very brief potted history, I did my pupillage at the self-employed bar. I didn't get tenancy, and I was what was called squatting, which is when you stay in chambers, you're not a tenant, and you basically get the briefs that other people don't want, can't do, if there's a surplus of them. I was also in a set of chambers that did a lot of government work, and at that time, all the government litigation was in one department called the Treasury Solicitors Department. They asked, do you have a baby barrister, a young barrister who can come in? And I moved into the government legal services for 3 months. 3 months became 12 years. I went from the government, and I didn't do financial services until the last 5 years there. So the first 7 years, I was acting as an employed barrister in a wide range of jobs, but not financial services. I went from government legal service to a law firm. I went from a law firm to HSBC, and I went from HSBC to Société Générale. And I'll explain a wee bit more about that. But what I wanted to do for you was basically to give you my top tips. I have been qualified for quite a long time now. About half my career was in the public sector, and now I've had about half my career in the private sector. And every now and again, I do reflect on what I've learned and how on earth have I ended up where I am today. And the first thing I would say is embrace opportunities, even if they're not what you expect. I said that I moved from the self-employed bar to the government legal service. I thought I was going for 3 months to do employment law litigation. 3 months became 6 months, became 9 months, because I ended up working on a huge equal pay case. And then I really enjoyed it. And when the government said to me, do you want a permanent job here? I said, okay. That had never been my plan. It was serendipitous. And so I did a couple of years doing employment law litigation. And you asked about oral advocacy. At that time, I did a huge amount of oral advocacy. What later happened, however, is that I had so many cases, and my cases were in the Supreme Court. I had to set up new tribunals because we had some weird and wonderful cases that hadn't been considered before. So we had to set up a tribunal to hear them. I didn't have the time. And so I ended up doing a bit less oral advocacy. I ended up just doing preliminary hearings, but I briefed and prepped all my witnesses. I went from there to a public law job. And so I did advocacy in the QBD at the time. I went from there to the Treasury, and at the Treasury I spent most of my time in Brussels negotiating on behalf of the UK. That's a different type of oral advocacy. I also represented the UK before the European Court of Justice, now the Court of Justice of the EU. So at the time, I was doing litigation for the government and very much using core litigation oral advocacy skills. So that was my first point. Embrace opportunities, even if they're not what you expect. It's also how I ended up in private practice. I was of counsel at an American law firm called Mayer Brown. When HSBC said we need a mat leave cover, we need someone to head up our global wealth management business. I wasn't a wealth management lawyer, but I thought I'd give it a go. And I've ended up now being an in-house lawyer. Again, that wasn't initially part of my plan. So embrace opportunities, that's my first point. My second point is that progression doesn't always have to be straight up. It can be linear. In government, what I realised was I could gather what I call tools for a toolkit. I started off doing private law litigation, and I thought that's really fun. What else can I do? Let's do a bit of public law litigation. Let's do those core administrative constitutional law problems you read about at university. So I tried that. After I'd litigated, I thought, what else can I do? Oh, I've not been in a government department. Let's go off to the Ministry of Defence. So I spent years in the Ministry of Defence advising the Secretary of State for Defence during the Iraq and the Afghanistani war. Absolutely fascinating, and the type of opportunity you don't get elsewhere. At the time, I was involved in drafting the Armed Forces Bill as well. I did the end of the military presence in Northern Ireland, and I was based in barracks in Northern Ireland when that was happening. So you can really be at the heart of government decisions, and it's a fascinating opportunity. After I'd done that, I thought, now what haven't I done? I haven't done much statutory instrument drafting, and actually I've never negotiated in Europe. Where do I get that opportunity? And it just so happened an opportunity at the Treasury came up. And that was the first time I started doing financial services. I wasn't looking to do financial services. I was looking to negotiate in Brussels. I was looking to draft statutory instruments. And that's how my whole second half of my career came about, because I actually really enjoyed financial services. That's my second point. You don't always go in a linear way. Progression's not always vertical. And also, you mightn't get the job you want initially, and that's okay. It might take one or two steps before you get there. When I figured out what job I actually wanted, I figured out that actually I really enjoy financial services regulation. I would like to work for a financial institution. I would like to work for a bank. I was at the Treasury at the time, and I thought that jump from the Treasury to heading up a financial services team in a bank is going to be hard. So I went via a law firm to build up a bit more experience in the private sector. Same with pupillage. I didn't get pupillage initially. I did well at bar school, but I didn't get pupillage. So I thought, what else can I do? I paralegaled for a year at Herbert Smith, and I tried again, and I got it the second time. And then the other thing I want to leave you with, I think it's always helpful to think how to assess a job opportunity. What criteria should I have in mind when I look at job opportunities? And I've got 5 different criteria that I've looked at throughout my career. I think firstly about, can I do the job? There's no point in wasting my time or somebody else's time if I can't do the job. I don't have to be able to do all of it, because what I also want, my second criteria, I want to be able to develop. So I want a job that I can do a lot of it, but I can still learn from. What else? You spend so long at work. I think it's really important to like the people you work with. It's really hard otherwise. So actually, I have nice people as a criterion. I also have people who care about what they do and are good at what they do, because if they're nice but don't really care, that's a really hard working environment. And then my final one is financial reward. the end of the day, we work to maintain a certain lifestyle. So for me, financial reward is something I think about. It's not the only thing. I've got 4 other criterion, and not every job I've had has satisfied all of those 5 criteria. Some have ticked 1 box only. It's been developmental. Others have ticked 3 or 4 boxes. I'd actually say it's not until this job that I've found a job that ticks all of my boxes. And then I just wanted to finish off on oral advocacy. I said at the beginning of my career when I litigated, I did a lot of oral advocacy. Since then, I've not stopped talking, but I'm talking in different fora. I'm media trained. I've spent a lot of time, more time than I really wanted to, on BBC News, on Sky News, on the radio, talking to journalists. I have advocated for positions in front of a variety of governments, just as Gaynor was talking about, and I still do that in front of various regulators. I talk about the development of the law, but I also defend my company's interests. Again, as Gaynor and Charlotte were talking about, you find yourself in front of very senior people in your organisation, in front of a board, in front of the CEO. Again, you use your oral advocacy skills to explain a certain position, to say why something should be done, why something else shouldn't be done. And that can be a very challenging environment if actually what you're saying is that a financially viable solution isn't lawful, so they shouldn't do it. You've got to be very confident of yourself to say no. And then you've also got to find a way to say, but there's another way to do it, and this is the way we should do it. So I do think that those of us at the employed bar constantly use our skills of oral advocacy in a variety of fora. So I'll stop there, but that's just what I wanted to cover.
No, that's brilliant. Thank you. What great advice. I'm interested as to how you can assess whether people are nice and care. How do you do that? Or is it sort of suck it and see, and if they're not nice, you move on? How does that work?
I had 8 interviews for this job. And by the time I got it, I had a fair sense of what the culture was like at Societe Generale, and it has played out. It has been one of the best places, if not the best place to work I've had to date. I think whether or not somebody's good at their job, that takes a little bit longer, although after an 8 interview process, you do get a sense for that as well. And also, I think that not every job has to tick every criterion, but it might mean that you stay longer if more of those boxes are ticked.
Yes, got it. Yeah, so I think I understood what you were saying. Correct me if I'm wrong, but I understood it to be essentially go in with your eyes open. And if you choose to drop one for a reason because something else is important at that moment in time, at least you know you've done that. That's sort of
exactly. And for
yeah.
a long time, I prioritized job development, the tools in my toolkit, over a lot of things.
Okay.
And then as I've got older, I think actually I want to work in an environment where I enjoy being, and that's more important.
Yeah. No, that's brilliant. That's amazing. Thank you. I don't know if there's any other specific questions for Alex. I have one, but it might be a bit unfair. I'll do it anyway, Alex.
Thank you, Dan.
Well, it's just a lot of us have talked about. I'm yet to speak, obviously, about myself, but a lot of us have talked about going from a self-employed pupillage and then sort of into the employed bar as an option available when it becomes clear that for whatever reason the self-employed bar isn't for you, or it's too difficult in some contexts or whatever. Would you recommend, nevertheless, that people wanting to get into the employed bar could still do a self-employed bar pupillage? Is that a route that you think could be consciously chosen rather than a bit more sort of accidental, which I think it is for most of us?
At first, I would say it was accidental and it was serendipitous for me. I hadn't planned to go to the employed bar. It was an opportunity that came up and I embraced it and really enjoyed it. I do think there is a lot to gain from a pupillage in the self-employed bar. That advocacy experience you get is unrivaled, and being on your feet in the second 6 of your career, it's hard work, it's a wee bit scary, but it gives you some amazing skills which really are transferable. the negotiations you've got to do, the drafting you do, all of those core skills I've used. And we've talked in the chat about the fact that actually, once you're qualified as a barrister, a self-employed barrister or as an employed barrister, you can then apply for a multitude of jobs. If a job is advertised for a solicitor, an employed barrister, or a barrister is still at the self-employed bar, can apply too. What tends to happen, you might do your job somewhat differently because you've got a slightly different skill set. I did more oral advocacy because I had that experience and I enjoyed it. And I've kept talking in my job because I enjoy it. And so I've had different experiences and opportunities come my way because of that. And I do think that in a number of our jobs at the employed bar, we actually do a bit more than just being a lawyer. We're a trusted advisor to the business. We're trusted to stand in front of a camera, to stand in front of a journalist, to stand in front of a minister or a regulator. And a lot of that is because of the skills you build up.
Yeah, no, that's really true, and I really resonates the idea of transferable skills. It's part of the process of gathering that toolkit together, I would say. No, that's really helpful. Thank you. I think one thing I'm just reflecting on now is that obviously we've talked a little bit about the sort of flexibility and the overlapping nature of the employed and self-employed bar, because Charlotte's obviously a living example of more recently that happening. But I think it's also probably fair just to say and to mention, I mean, we're not sort of pushing the bar at all costs here, that the work of a solicitor can also overlap to some extent with the work of an employed barrister, and that would and even a self-employed barrister, because solicitors can get higher rights of audience, and many do. So just for the full picture, obviously we are all barristers, and we think there's something in that, but for the full picture, there's also solicitor routes that kind of overlap. These three sort of bubbles, if you like, all overlap in a way. And so I think it's fair to say that I myself am currently an employed barrister in a law firm, and I have been in law firms ever since I qualified, essentially, but I did do a self-employed bar pupillage. But quite often I find myself saying to people like clients, oh, just treat me like a solicitor. I very much do the work of a solicitor. And that is because I need to make the distinction of that I'm probably not going to be the person in court. I'm a litigator, but I'm probably not going to be me going to court, mainly because barristers of the same level of call as me are cheaper. They don't carry the overheads of a firm with them. So I say that to clients, and it is true up to a point, and that's the overlap I'm talking about. But it's also not true for the reasons that Alex mentioned, which I think is this transferable skills and this collection of skills as you go along, which gives you a slightly different perspective on things, and it makes you valuable in different ways. So yes, I get consulted by clients, but I also get consulted internally about the workings of the firm and business things to do with the firm, or kind of like legal sort of intricacies to do with the running of the firm, for example. So that is where you become a trusted advisor to people around you as well as the people you're serving. So I just wanted to try and be fair to give the sort of full picture there, that there are other ways to do it. And in fact, to complete that picture, a number of solicitors have ultimately moved to the self-employed bar. They've gone that far. So Angela Kodopoulos KC, for example, I know of Adam Gamsa. These are names that are all of the bar that I'm familiar with, which is the intellectual property bar. But it really does happen in that direction as well. So there is this degree of flexibility, but you just need to be aware of what the opportunities are and the options, and how you could best move between them if needs be, or if you just so desired. So I think that's just to try and contextualize things. So my own background is that I did qualify in a chambers in London, intellectual property specialist chambers, and like many other people, did not then get taken on as a tenant. So getting pupillage is hard enough, but getting kept on as a tenant is a whole other thing, and there's no guarantee that by getting pupillage you will then necessarily be at that chambers for the rest of your life. So I did not get taken on, and sort of with hindsight, I sort of say that I had a choice to make whether I stayed at in a chambers environment, self-employed bar environment, and did something other than intellectual property. That was possibly an option open to me, not that it felt like it at the time, or that I continued to do the kind of law that I liked and tried to look for opportunities to do that. Now, my natural instinct at the time was to go to look for law firms. I didn't really know there might be other options, if I'm completely honest. And even law firms at the time, and this was a while ago, were a bit reticent about taking on barristers because, you know, barristers might have a bit of a reputation as being a little bit radical, wild card, sort of difficult personalities. Now, I don't think that is the case anymore. I mean, there are some, but they're very much self-employed. But I think that's just what I found, and therefore I ended up working in a regional law firm in a corporate department to start with, and then I felt like I needed to get back to what I liked, which was the more litigation-y stuff. So I then moved firms, again a regional firm, where I was in their general commercial litigation department, but doing some IP. And then I really felt I needed to properly focus on the IP. So that's when I moved to London to do intellectual property litigation purely. So again, there's different ways to skin a cat, you know, coming back to things that I think our whole panel have said, or particularly Alex, actually, in terms of not just going in a straight line. If you desperately want to be in London, that doesn't have to be your first step. You can work your way to London by proving yourself in other environments and becoming a desirable person with employable skills. So that's just sort of reflected in my own experience. So then I did do that, and then I actually then went to Paris for 2 years to work in a law firm there. This is just post-Brexit referendum, but pre-actual Brexit. Came back for personal reasons, essentially, and then I became a partner in the law firm I'm at now. One interesting anecdote perhaps about self-employed or employed status is that your practicing certificate has to specify which camp you fall into. But in France, all lawyers who work in law firms are self-employed, because there is this kind of rule of independence that lawyers sort of tend to have, which means they can't be in the, you know, they can't be coerced or influenced by their employer. They have to be giving independent advice. So it's sort of this halfway house between being a barrister and a solicitor. But when I came to try and figure out what my practicing certificate would say, I had some very interesting conversations with the Bar Council, essentially, where they ended up saying, well, you just decide what you want, doesn't really matter, because it was such a sort of edge case. So you come across these sort of slightly odd things sometimes, but so I very much enjoy the work that I do, and I feel like I do the work of a solicitor, actually, but with a slight advantage, with a slightly different perspective, and I feel like that sets me apart and allows me to sell that as an attribute that sets me apart in that way. So the other thing that I do is that I was appointed as a deputy district judge in the county court about 8 years ago now. And that is essentially a role whereby when they have need for a district judge replacement because there's illness or, you know, training or just an overworked list and not enough people to do it, then there's a list of vacancies that you can sign up for, and you go to court and you do the judging. And that's been very interesting, because that is the other side of the coin. That's the other side of the bench, from the sort of self-employed barrister perspective and also the litigator perspective, where being the person who has to make decisions does give you another perspective again. So I've also got that, which I then bring back into my day job. So a bit like Alex, I'm probably gathering skills, and I'm interested in stretching myself a little bit and learning new things, all the while enjoying working with a team of people in an organization that can support me with a degree of knowing how much money I'll have each month, and all of those sort of more sort of mundane things, means that I've never really felt like I needed or wanted to strike out on my own and go back to the self-employed bar. So I think for me, the only real driver, one of Alex's criteria, would be money. I think I probably could get paid more at the self-employed bar, but money isn't everything. So that's sort of my story, contextualized, hopefully helpful. I don't know if anyone on the panel has any questions for me. Anyone has anything that arises out of that? No, that's fine. If anyone in the audience has any questions, obviously very happy to answer them specifically, or we can throw things open to the panel more broadly. I don't know if Fion's got any thoughts or insights to offer as well. Obviously, welcome those. Any questions from anybody? Feel free, don't be shy. put your camera on, put your microphone on. This is a chance to do some advocacy. So there are a number of questions that were in the chat. I think they've probably all been answered. A slightly niche one from Simon there about ACOBA, which is the government body that deals with trying to make sure that ministers and senior civil servants don't benefit when they leave office by going into private companies. I think Charlotte answered that one to say that's probably not very relevant for most of us. But I mean, there are a lot of other questions that people might have.
Could I just say,
yeah, please. Sorry.
Could I just say something about that as well? It's interesting because you're right. ACOBA is there to stop senior civil servants leveraging their connections in government, particularly in relation to lobbying. On the other hand, those of us who have worked in government have some great skills, some great contacts, which we've then used to further our own careers. One of the things I do talk about is the fact that I have negotiated, drafted legislation, which I'm now advising firms on, and I use that as an advantage. And so I talked earlier about your jobs not always having to be linear and how you can take something from one job and utilize it elsewhere. That very much works for key experiences as well. And those very things that ACOBA is designed to stop actually don't apply to us, because what we've built is key knowledge and key experience, which we leverage in different roles.
Yeah, absolutely. I think that, when you've been on both sides of things as well, like, acting for claimant or defendant, there's different things, the same sort of thing. I know somebody who used to act for, I think it's the dentists regulator, and then for dentists, there's all these, you can understand a system from different, and there's different ways, and there's absolutely no reason why you shouldn't be allowed to benefit from that knowledge.
Yeah. And I also wanted to give a plug to the government legal department. It's a fabulous place to work for a number of reasons. One of them is there's so much variety. They do offer pupillatures as well as training contracts. So that, as does the CPS, as do a number of the regulators, and not just in financial services. But the government has a huge variety of different jobs. I skated over the surface of all the different things I've done, but certainly when I was there, I wouldn't say it's 50-50. There's a huge amount of employed barristers, including those who qualified in government, but those who came to government later. And many of them move on to other opportunities. One of my friends is general counsel at Ofgem. One of my friends is general counsel at Imperial College London. All employed barristers I worked with in the government legal service. And the government legal service gives you very many transferable skills, not just knowledge and experience of working in different areas. You litigate, you draft, you negotiate, you sit behind a minister in the Houses of Parliament, advise them how to answer questions. I would 100% recommend it, either as a lifelong choice because the variety is so huge, or to gain some experience which you then take elsewhere.
Absolutely. No, that's brilliant. Thank you. Plug noted. I just have seen some questions come in. Mia Jane has asked what my experience is like being on the other side of the bench and what's the biggest lesson. I think in relation to my deputy district judging, what I have appreciated from it is suddenly, when you're acting for somebody, you really quite often quite buy into your own arguments, you buy into the case and the sort of the impetus behind it, so much so that sometimes you can't see the wood for the trees, and as the judge you don't care about the extraneous stuff, you only care about the really relevant stuff for the decision you have to make. So I think the lesson for me now, whenever I go before a judge, as I say, not the one speaking, but you have to prepare the documents, you have to decide what your strategy and position is. Going before a judge, know what you're asking the judge to do, know what the powers of the judge to do it are, and know what information the judge needs to reach that. Everything else is irrelevant. Everything else is just it's it's decoration, explaining how somebody was annoyed about somebody's, I don't know, customer service experience. You know, the sort of thing I say when I have litigants in person before me is, I appreciate there may be a load of issues here. Only some of them are the ones that I can deal with in this court of law. You know, so I'm not going to be able to say, yes, their customer service was bad and they were rude to you. There's nothing legal about that. That's just something you're going to have to decide amongst yourselves. So I think for me, it's trying to cut through all of that, really slim it down to the really necessary stuff. A little bit of color is okay here and there, but I think it's that for me is the major lesson. So that was helpful for me. Just adding on to what Alex has just said, is sort of quite heavily implied there, is your network as well. Grow your network. You know, grow a network of people who respect what you do and how you do it. And over time, particularly these days with LinkedIn, you know, you suddenly find you've got 1,000 connections. And if you're quite careful about curating those connections, they're real connections. They're not just people you've never met. And I think that's something that you can start now. And you really should start now. I'm still friends with people from bar school and from City, actually. And I phoned one of them up the other day because I was doing it's an IP case to do with infringement in relation to a supermarket product. And there's a question about who was the importer. And so I rang up my shipping barrister, KC friend, to ask him some questions about kind of shipping law terms that I was reading in these contracts about shipping. So your network can help you in so many ways, and likewise he brings you up about IP questions. But I just think that's part of it as well. If you grow your network, that's part of making opportunities for yourself. So I can see from Simon's comment in the chat as well that he used to be a journalist, and that again will bring this sort of diversity of experience is all really great stuff, and part of the networking that he will undoubtedly have already done. I think everybody should be keeping an eye out for that. So I don't know if anyone else on the panel has any other pearls of wisdom, advice, tips to offer. Okay, I've just seen Joseph's asking for a friend comment. Go on, Charlotte. Go on, you can do this one. Money is property after all.
Indeed, it's a human rightness, but I think it really depends on the practice area and the organization and or set of chambers that you're in. So my practice is primarily commercial chancery, and I did a speech about this actually last week. I have tripled my earnings compared to what I earned in my law firm. So I'm just really straightforward about it, because I don't know what other job you would work in where no one tells you what you could earn. I think that's ludicrous, and that's a problem with the self-employed bar, that opacity around earnings and what money you might or might not be able to take home, or whether you'll be able to pay your mortgage. So from my perspective, monetarily, it's been better for me. But at the same time, I had a case that was due on next week. It's come out my diary. So sometimes there will be peaks and troughs, and you can think, oh, this is great, but you have to remember to keep money aside for tax, national insurance, chambers fees, practicing certificate. There are all these different things that you don't have to think about when you're in an employed environment. Pension. No, I do contribute to the pension. I love pensions. Yes. And insurance products. So for team financial services, so it really does depend. And also from the financial services side of things, if you perform well at your job, there are bonuses. So actually that can make a massive difference to your base pay. So you're actually in a pretty similar position to your equivalent at the self-employed bar. So it totally depends what suits your life. There is no right answer, but I advocate strongly for both, whichever suits you.
Yeah, I think it might depend on the area of law as well, how that plays out. So it's a bit of a difficult one to answer. It's not necessarily always going to be better at the self-employed bar. I'm thinking maybe criminal practitioners have it particularly difficult at the self-employed bar, but yeah, I think possibly there is something to be said for that, and it also might depend on where you are in your career. I mean, if you're an equity partner of a big law firm making loads of money, then maybe that's enough. That's not me, by the way. But it is possible, that is out there. So I think it's just a question of perhaps doing a bit of research and just soaking up some of that knowledge if you can. It's a bit hard to be definitive. Gaynor, did you have anything else you wanted to add?
No, I don't think so. I think we've covered loads actually tonight, which has been really good. I hope everyone's got something out of it.
Great, thank you. I don't think I have anything else unless there's any other questions. Perhaps pass back to Fionn for any final thoughts or queries.
Could I just say one thing, actually?
Of course, yeah.
And I think it probably has come across, but it is worth stressing. It isn't easy. And especially when you're at the start of your career and you hit these hurdles, you don't get pupillage, you don't get tenancy. It feels horrid. It really does. But hopefully by listening to us, you can understand that actually that happens more often than you think it would. And it might be a hurdle, but you can get over it. Or sometimes you go under it, around it, but you do pass it somehow. And now at our stage in the career, looking back, it wasn't unsurmountable. And we've all ended up, perhaps not where we thought we'd end up, but generally in places where we are happy doing what we do. Otherwise, we wouldn't still be doing it. So don't get disheartened. Yes, it is difficult, but you're not alone in finding it difficult. And people do succeed, just often in different ways than they first appreciated.
Yeah, and I think we all said it, just take a chance as well. Don't be afraid to just give something a go, because until you do it, you won't know that that's your niche. So
Completely, thank you. My only last tip to people is don't be afraid to put your cameras on next time. We'd like to see your faces and rather than shouting into the void. Otherwise, hand over to you, Fionn.
Yeah, thank you very much. Thanks to everyone for speaking today. I think just to go back to the questions about pupillage, all pupillages now, save for companies that have a waiver, must be advertised on the pupillage gateway. So that includes the employed bar. They are very unlikely to use the gateway mechanism for administrating their pupillages, so they will simply advertise on there, but they will not use it for their internal processes. Obviously, it wouldn't work for the employed bar, but all of the pupillages will be advertised there. But for those of you that are not necessarily going to be checking the gateway every day for unusually timed pupillages, then clearly the CPS will advertise their pupillages and the dates of them on their website as well, as will the government legal department. So both of those are huge and significant employers, and they are definitely worth applying for. But don't forget that they will have a slightly different way of assessing their pupils. So, for example, the CPS, you have to deliver a pre-recorded talk on a matter that they will decide this year, and that's always the case. So just think about trying to find out, if you are interested in applying for the CPS or the Government Legal Service, how they recruit their pupils, so that you're ready when the advert comes up to think about how their individual way of making those decisions and how you can best put yourself forward for that. And then you do have the smaller pupillage employed bar offerers as well. So there will be smaller pupillages on there. I think, as Alexandria said, in relation to regulators, they don't always advertise every year. So you'll have different people or different organisations advertising each year. You can't be guaranteed who's going to advertise each year. But the Nursing and Midwifery Council will usually offer a pupillage every year or every other year. Certainly some local authorities will offer pupillages. And some solicitors' firms are now offering pupillages as well, and possibly some finance houses as well. So it's just about being on there and checking quite regularly if you want to look for those smaller niche pupillages, because they must advertise on Gateway, but you won't necessarily know that they are advertising, and that's difficult to know. So you just have to to persevere, but you do need to take those applications seriously. They are challenging. There will be lots of rounds and there will be high expectations. So if you are making those applications, then they are also, you know, there are a large number of people applying for them and you have to take them seriously. In relation to doing a pupillage and then moving over, obviously most sets of chambers, you know, the pupillages are funded by individual members of chambers, so they're not very likely to be ecstatic if you let them know that you're applying for a pupillage but aren't committed to the set, because obviously all pupillages are paid now. So I wouldn't advise that that line of application. But you've heard a lot of interesting things tonight. I don't know if any of the panelists want to say any more, but if not, thank you everyone for coming. Do attend the further lectures, and I think the date is the 3rd of December at 6 o'clock, and we'll certainly be sending around information and advertising about that. So from me, thank you very much.
Thank you. Thanks all for attending and for the panel.
Thank you.
Good
Thanks
night
for
all.
listening, Dan.
Thanks, everyone.
Thanks. Bye-bye.
Good luck, everyone.
Bye. Bye.